Did you know that if someone passes away and does not have an estate plan in place, their house, many of their investments, and other assets must go through an expensive and lengthy process called probate? There will be fees and costs involved that will come out of the proceeds of the estate, and that's not even the end of it. Over the next few minutes, I'm going to share the 3 things that people face when going through probate. Hi, I'm Mitch Greene, a partner at Kramer, Greene, and for the past 35 years, I've helped business owners in various industries like healthcare protect their businesses from unforeseen circumstances. If you're trying to protect your assets or business and need legal assistance, I'd like to help you create that playbook. So visit my website and schedule a complimentary consultation so I can walk you through the process. When your loved one passes away and has an estate plan, including a revocable living trust in place, you might think that handling their estate should be a straightforward process. However, when they do not have a revocable living trust in place and merely have a will, that is typically when their estate assets will need to go through the probate process. Probate is known to present various challenges during the probate proceedings, including challenges to the will by family members, potentially significant delays in distributing the estate proceeds, and expenses that may diminish the estate's value. The first thing you need to know is that a will can be challenged. Even if your loved one has a will in place before their death, another family member or interested party may attempt to challenge their will. A family member or other interested party who is dissatisfied with the terms of the will may take steps to try and invalidate the will on various grounds, such as the invalidity of the will due to the proper execution of the will under Florida law, undue influence on the deceased at the time they made the will, lack of mental capacity of the deceased at the time they made the will, or if the will is executed through fraud, duress, or by mistake. Will contests can be expensive and result in substantial delays in an already lengthy probate process. They can also further strain relations between siblings or other family members. As a result, individuals should engage in careful estate planning well before their deaths with the assistance of an estate planning attorney to ensure that their wills are valid under Florida law and not susceptible to will contests. The second thing you need to be aware of is the length of time involved in the probate process. If a deceased person's assets are not part of their probate estate, their heirs cannot receive their inheritance until the probate process is complete. As a result, heirs typically must wait several months for the probate process to finish before they can receive their inheritances, even under the best possible circumstances. If the decedent leaves many debts, it can take some time to determine the validity of these debts and to determine their proper disposition. In many cases, a probate attorney may be able to wrap up a probate case in 6 months or less, but in some cases it could take as long as 6 to 12 months or longer, depending upon the circumstances. The third thing you need to be aware of are the costs involved during the probate process. Depending upon the complexity of the estate, probate proceedings can be quite expensive. These expenses decrease the inheritance each heir will receive from the estate. Some of the expenses that the estate must bear include debts of the decedent, costs of appraisals of probate property, costs of realtors, accountants, tax preparers, and other professionals the estate must employ, attorney's fees, and court costs. So I hope this video gives you a better understanding of the 3 things to be aware of regarding the probate process. Whether you're trying to protect your assets, start a business, sell a business, or navigate the laws within your business, we provide a one-stop option for everything. If you have questions surrounding your business and legal needs, schedule time to meet with our firm today and take the first step in protecting your business and financial future.